Good morning. I would like to welcome everybody present here. I open meeting number 27 of the 52nd session of the Committee on Economic, Social, Cultural Rights. Today we will consider the second periodic report of the Republic of Serbia. I would like to extend my cordial welcome to the delegation of Serbia headed by Madam Zuzanna Paunovic, Director of the Office for Human Rights and Minority Rights of the Government of Serbia. Madam, welcome. The head of delegation is accompanied by His Excellency Mr. Vladislav Mladenovic, Ambassador, Permanent Representative of Serbia to the United Nations Organization in Geneva. My cordial welcome is, of course, also extended to other members of the Serbian delegation, especially those who traveled from Belgrade, especially to attend this dialogue. Let me also welcome all the observers, including those who have come to Geneva from Serbia to attend the review by our committee of the Serbian report under the Covenant. Today, the meeting is also attended by students from the University of Padova under the tutorship of Professor Paolo De Stefani. Let me say how much the committee appreciates your interest in its work. Maybe there are some future members of this or another committee among you. What I wish you, certainly. Now, allow me please to briefly outline the proceedings today. And we will begin with an opening statement by the head of the delegation, after which I will give the floor to committee's rapporteur on Serbia, Mr. Walid Sadi. Now, the introductory remarks will open the part of the meeting dedicated to the exchange between the delegation of Serbia and the committee. In accordance with our preliminary agreement with the delegation and with a view to making our dialogue most effective and time efficient, the dialogue will be conducted under 4 thematic clusters based on the Covenant. At the beginning of the exchange between the committee members...
There's a problem with the interpretation.
Okay.
They won't be able to do it.
Okay. At the beginning of the exchange between the committee members and the delegation, I will ask my colleagues to raise questions on the first cluster. These are Articles 1 to 5 of the Covenant, and they are related to some general issues. In particular, under this cluster, the committee members usually address issues related to the domestic system of the implementation of the Covenant, to the judicial system, to the issues of equality and non-discrimination, and so on. After having finished questions under first cluster, we will immediately, in accordance with the agreement with the delegation, move to the second cluster questions. And these questions will be related to Article 6 to 9 of the Covenant. These provisions deal with the labor rights, with trade union rights, and with the right to social security. After these 2 sets of questions, we will adjourn the meeting for some 15 minutes in order to give the delegation the opportunity to organize the responses. Then we will move to this responses part of our dialogue. And however, we would like to kindly ask the distinguished delegation to provide responses on the cluster-by-cluster basis. And the reason for that is, first, that it helps to better organize the dialogue, but second, at the end of each set of responses under each cluster. We would like to open the floor for the committee members to come up with some supplementary follow-up questions. This will help also to make the dialogue even more interactive and lively. At 12:30, approximately, we will again stop these responses with the permission of the delegation in order to enable the members of the committee to come up with questions related to the remaining clusters. This means cluster 3 and cluster 4. Cluster 3 is related to Articles 10 to 12, and these are, in general terms, articles related to dealing with family issues, family protection, women, children, including the right to adequate standard of living, again including the right to food, right to drinking water, right to housing, etc. And then Article 12, right to health. After having finished these questions, we will address the fourth cluster, Article 13 to 15, and these are provisions which address the issues of education and culture. Once the questions under the clusters 3 and 4 will be posed to the delegation, we will arrive at the lunch break, and we would like to give the delegation the opportunity to organize responses to these remaining clusters 3 and 4, and therefore we would like to put the questions before lunchtime. In the afternoon, we will continue with our dialogue, and at the end of the exchanges, the head of the delegation will have the opportunity to present her concluding remarks. Also, the rapporteur will be in the position to share with us his first impressions from our dialogue. This is the overall scenario for today, and if you allow me, I would like now to turn to Madam Zuzanna Paunovic, the distinguished head of the delegation, to present her introductory remarks. The floor is yours, Madam.
Thank you. Poštovani gospodine predsjedavajući.
Dear Mr. Chairman, distinguished members of the committee, ladies and gentlemen, allow me on behalf of the Republic of Serbia to express satisfaction with the opportunity today to present the second periodic report on the implementation of the International Covenant on Economic, Social and Cultural Rights. Mr. Chair, at the outset, I would like to say that the Republic of Serbia is an independent country since 2006, committed to building a democratic society, which means, above all, respect for human and minority rights. According to the Constitution of the Republic of Serbia, containing a broad catalogue of human rights, the generally accepted rules of international law and ratified international treaties are an integral part of domestic legal order and applied directly. The Republic of Serbia is a member of 8 core international treaties in the field of human rights and a signatory to the International Convention on the Protection of Rights of all migrant workers and members of their families. Legislative activity in the Republic of Serbia was very intense during the reporting period. A large number of laws was adopted and a vast number of international conventions were ratified, which the most important ones from the aspect of human rights are the Convention on the Rights of Persons with Disability and the optional protocol to the Convention, the International Convention on the Protection of all Persons from Enforced Disappearance, the revised European Social Charter, the Council of European Convention on Action Against Trafficking in Human Beings, the Convention on the Protection and Promotion of the Diversity of Cultural Expressions, Council of Europe Convention on the Protection of Children Against Sexual Exploitation and Sexual Abuse, and Council of Europe Convention on Preventing and Combating Violence Against Women and Domestic Violence. Mr. Chairman, I would like particularly to draw your attention to the fact that based on the Resolution 1244 of the UN, Kosovo and Metohija is an integral part of the territory of the Republic of Serbia. Serbia, as a signatory country, is not able to implement the International Covenant on Economic, Social and Cultural Rights and oversee its implementation in Kosovo, since the administration of the province has been completely entrusted to the United Nations Interim Administration Mission in Kosovo, UNMIK. That is why the report before you does not contain detailed information on the implementation of the Convent in this part of the territory of the Republic of Serbia. In this regard, I would like to welcome the fact that the Committee on Economic, Social and Cultural Rights accepted the proposal of the Republic of Serbia and asked UNMIK to compile information on the implementation of the Covenant in the territory of Kosovo and Metohija. And bearing in mind that information, we could see the idea was to have full information in the territory of our province. In this context, we would like to receive new information. And in this context, the government of the Republic of Serbia is ready to provide all information and thus contribute to the work of the committee in connection with the review of the implementation of the International Covenant on Economic, Social and Cultural Rights. Mr. Chairman, the constitutional system of the Republic of Serbia provides that all are equal and everyone has the right to equal legal protection without discrimination. We may introduce special measures that are not considered discriminatory to achieve full equality of persons or groups of persons who are substantially in an unequal position. In March of 2009, the Prohibition of Indiscrimination Act was adopted as a general anti-discrimination law, envisaging a wide range of prohibited grounds of discrimination. According to the Act, discrimination and discriminatory treatment means any unjustifiable differentiation or unequal treatment or omission in relation to individuals or groups, as well as their family members or persons close to them, in an open or covert manner that is based on race, color, descent, citizenship, nationality, or ethnic origin, language, religious or political beliefs, sex, gender identity, sexual orientation, property, birth, genetic characteristics, health status, disability, marital and family status, convictions, age, appearance, membership in political, trade union, and other organizations, or other actual or supposed personal attributes. The Act prescribes two methods of achieving protection of citizens if there is a violation of protected rights, either by filing a lawsuit or filing a complaint through a separate independent state body, the Commissioner for Protection of Equality, appointed by the National Assembly, the Parliament, in 2010. Discrimination has been foreseen as a criminal offense under the Criminal Code, and in 2012, obligatory aggravating factor was introduced in sentencing for offenses committed out of hatred based on race and religion, national or ethnic origin, gender, sexual orientation, or gender identity of another person, which the court shall appreciate as an aggravating circumstance whenever it is not prescribed as a characteristic of the offense. In June 2013, the government adopted a strategy for prevention and protection from discrimination, drafted with the active participation of representatives of the civil society organization. This document is dedicated to preventing discrimination and promoting the status of 9 vulnerable groups that are most often subject to discrimination, such as women, children, persons with disability, older persons, LGBT persons, national minorities, refugees, internally displaced persons, and members of other vulnerable migrant groups, as well as those whose health may be the cause of discrimination, and members of small religious communities and religious groups. An action plan for the implementation of the strategy, which is expected to be adopted in the first half of 2014, has already been drafted. Mr. Chairman, regulations and strategic documents adopted with the goal of improving the position of the Roma, addressing issues involving refugees and internally displaced persons, protection of persons with disability and promotion of gender equality are of exceptional importance for protection against discrimination in the Republic of Serbia. According to the census of 2011, the population of the Republic of Serbia is 7,186,862. The average age of the population is 42.2 years and the average household size is 2.88 members. According to the census, there are 147,604 Roma, or 2.05% in Serbia. However, many studies indicate that the number is much higher, and estimates go as far as beyond 250,000. The Republic of Serbia has established a strategic and institutional framework for the advancement of Roma. The strategy on improvement of the status of Roma was adopted in 2009, and basic principles and values underlying the strategy include the state's duty to care for and respect, protect and fulfill the Roma population's legal rights, full and effective inclusion of Roma in all areas of social life, respect, recognition and promotion of diversity, equal opportunities based on equal rights, gender equality, prevention and fight against all forms of discrimination, implementation of affirmative action measures. The two action plans have been adopted to implement the strategy in 2009 for the period of 2009 to 2011, and the second one in 2013 for the period until January 1st, 2015. Measures or activities have been defined in the action plans and make the recommendations and priorities defined in the strategy operational for each of the 13 areas of importance: education, housing conditions, employment, internally displaced persons, return on the basis of readmission agreements, personal documents, social security, healthcare, status of women, information, culture, political participation and representation, and non-discrimination. Serbia has established close cooperation with the EU and the OSCE and shares 10 years of experience in working to improve the status of the Roma minority and integrating them into our state. In order to implement the strategy for improvement of the status of the Roma, the international community has provided financial and technical support to state agencies in charge of activities and actions defined by the action plan. On 2nd of August 2012, the government of the Republic of Serbia established the Office for Human and Minority Rights, which took competencies over the implementation of policies and projects relating to the social inclusion of the Roma. The Serbian government established the Council for Advancement of Roma and the Decade of Roma Inclusion during June 2013. Professional, administrative and technical support to the Council's work is provided by the Office for Human and Minority Rights. A Roma Inclusion Office has also been established at the level of an autonomous province of Vojvodina. The Republic of Serbia remains the country with the highest number of refugees and internally displaced persons in Europe even today. Although the number of refugees is reduced primarily due to integration, there are at present 57,247 refugees and over 209,000 internally displaced persons. 23 collective centers, 9 in Kosovo and Metohija, accommodate in total 1,641 persons, namely 341 refugees and 1,300 IDPs. The Serbian government has adopted strategies for determining main objectives and courses of actions in resolving problems that involve refugees and internally displaced persons. Over the course of 2009, adopted the strategy on sustainable return to Kosovo and Metohija, and in 2011, the national strategy for the problems of refugees and IDPs in the period from 2011 to 2014. The Commissioner for Refugees works on improving living conditions and promoting the socioeconomic status of internally displaced persons, with special attention dedicated to members of the Roma minority, which has been
Gospodine predsjedavajući, Republika Srbija 2006. godine
group within the internally displaced population
invaliditetom, koji na sveobuhvatan način određuje pojam diskriminacije osoba s invaliditetom, posebne oblike diskriminacije, kao i posebne slučajeve diskriminacije prema osobama sa invaliditetom u pojedinim sektorima organizovanog društvenog života.
Excuse me, we don't have an interpreter.
Okay, sorry. Okay, we got it. Thank you. Okay, you're welcome. Sorry. From proceedings before public authorities through employment and employment relations, education, healthcare, use of public services and property, access to public transports, and participation in citizens' associations, to quality of organizations of persons with disabilities, and protection of these individuals from discrimination, married and family life. Significant progress in the field of labor and employment was made in 2009 with the adoption of the Professional Rehabilitation and Employment of Persons with Disabilities Act. The government of the Republic of Serbia also adopted the strategy for improvement of the position of persons with disabilities in the Republic of Serbia for the period 2007-2015. In 2009, the Republic of Serbia adopted the Gender Equality Act. The basic purpose of this act was to create conditions for conducting a policy of equal opportunities for men and women to exercise their rights, to take special measures and prevent and eliminate gender-based discrimination. The Act defines more precisely the prohibition of gender-based discrimination, the rights of both genders in the field of employment, social and healthcare, family relations, political and public life, education, culture, sports, and judicial protection. The basic premise for all the activities and measures the Republic of Serbia is taking towards the promotion of gender equality is a national strategy for the improvement of women's position and promotion of gender equality, which the government of Serbia adopted in 2009. This document determined the entire state policy towards the elimination of discrimination against women, improvement of their status, and integration of the gender equality principle into all areas and institutions of the system, as one of the elements of social modernization, democratization, and a faster, more even, and more efficient social development, all in line with equal opportunities policy proclaimed in the Constitution. An action plan for the period 2010-2015 was adopted for the implementation of this strategy. Mr. Chairman, the Republic of Serbia is a member of the International Labour Organization and has ratified a number of conventions adopted under the auspices of this organization, which, among others, refer to minimum wages and equal rewarding of men and women in the workforce, weekly rest and paid leave, workplace protection and compensation in cases of accidents or occupational diseases, health care, and occupational medical services. The Constitution stipulates that all jobs are available to everyone under equal conditions. Everyone has a right of respect to one's own person at work, safe and healthy work conditions, necessary protection work, limited working hours, daily and weekly rest, paid annual leave, fair wages, and legal protection in case of termination of employment. No one may renounce any of these rights. Labor law matters are primarily regulated by the Labor Act and the Employment and Insurance in case of an Employment Act. All employees are guaranteed equal earnings for the same work or work of equal value performed with the employer. Employment is run by the National Employment Bureau, which has the duty to provide free job searching services for interested unemployed persons. In May 2011, the National Employment Strategy for the period 2011-2020 was adopted. The primary employment policy objective is to establish a fixed, stable, and sustainable employment growth trend and to have the employment policy and labor market indicators fully harmonized with the practices of EU countries. In the first quarter of 2014, the total unemployment rate in the Republic of Serbia was 20.8% of the population. The total employment rate was 38.4%, with the employment rate for men amounting to 45.7% and for women 31.6%. The freedom of association of labor unions is determined by the Constitution. Conditions for the registration of unions in the register are identical for all unions, irrespective of their level of establishment. The registration procedure is simple, thus resulting in over 20,000 unions being registered on the territory of the Republic of Serbia from 1991 to date. The protection of rights of union representatives is stipulated by the Labor Act, pursuant to which an employer may not cancel a union representative's employment contract or in any other way put a union representative in an unfavorable position or do so to a nominated or appointed union representative during his or her service and 1 year after the termination of the service, if the employee's representative is acting in line with the law, general acts, and his or her employment contract. The Criminal Code incriminates the criminal offense of prevention of political union and other association and activity. The right to strike is guaranteed by the Constitution. A strike is conducted in accordance with the law and collective contracts, while it may be exclusively limited by law in accordance with the nature or type of activity in question. Mr. Chairman, the Constitution guarantees the rights of employees and their families to social protection and social security, and wage allowances in cases of temporary inability to work, and wage allowances in case of temporary unemployment. Certain categories are guaranteed the right to special social protection. The state is under a constitutional obligation to manage funds for different kinds of social insurance. The Constitution specially guarantees the right to pension insurance. Social protection includes pension, disability, health insurance, and insurance in case of unemployment. There are multiple laws in the Republic of Serbia which regulate social insurance matters. Mandatory insurance covers all employees, persons independently performing activities, as well as farmers, and ensures the rights of insurances in case of old age, disability, death, and bodily harm caused by a work injury or occupational disease. In addition to mandatory insurance, there's also the option of voluntary insurance for persons who are not mandatorily insured under the terms in the scope and manner prescribed by law. According to the Social Protection Act, the purpose of social protection is, on the one hand, to achieve or maintain minimal financial security of citizens, and on the other hand, ensure the accessibility of services and execution of rights in social protection. Additionally, the system of social protection is directed at creating equal opportunities for social inclusion. The Act introduces numerous new solutions, which are to improve the position and help the social inclusions of persons belonging to vulnerable groups. The 2010 amendments to the Pension Disability Insurance Act tightened retirement conditions, while the existing limits will gradually grow until 2023. According to the 2011 census, the Republic of Serbia has 4,215,642 economically inactive citizens, which 1,628,428 are pensioners. During 2013, there was a total of 1,722,649 beneficiaries on the basis of pension disability insurance. The Constitution guarantees special protection to families, mothers, single parents, and children. Special protection is guaranteed to expectant mothers before and after childbirth, as well as special protection to children without parental care and children with physical or mental disabilities. The Constitution prohibits child labor with respect to all minors under the age of 15, while older minors are prohibited from doing labor which may negatively affect their health or moral. The Family Act prohibits domestic violence, establishes the right to protection against it, and prescribes a special court procedure for legal family protection against violence. In the system of social protection, all children registered with the social welfare center on any basis, especially as neglected or molested, are covered by a certain type of social intervention. The competence of a social welfare center, particularly that acting in the capacity of a guardianship institution, is to provide basic protection of rights and interests of the child. The government of the Republic of Serbia in 2011 adopted a national strategy for the prevention and combating of domestic and intimate partner violence against women. In November 2011, the General Protocol for Action and Cooperation of Institutions, Bodies, and Organizations in cases of domestic and intimate partner violence against women was adopted. It establishes cooperation between ministries competent for labor and social policy, justice, internal affairs, and health. For the first time ever, a child witnessing domestic violence has been explicitly defined in the protocol as a victim of domestic violence. Mr. Chairman, the Constitution of the Republic of Serbia guarantees the protection of physical and psychological health. The health care system is first and foremost regulated by the health care, which governs the subject of the state's care of citizens health, organizational institutions in the health system, and the rights of patients. And the Health Insurance Act, which regulates the insurance system, general rights and duties of insurance users, as well as the manner of exercise of rights. In the Republic of Serbia, there's a trend of developing a comprehensive system of mandatory health insurance that will include all citizens, particularly those belonging to groups deemed marginalized and who are provided health care from the budget of the Republic of Serbia. The Constitution establishes the right and obligation to primary education, the right to secondary education. Primary education is mandatory and free, while secondary and higher education is financed from the budget of the Republic of Serbia, depending on the candidate's success or through self-financing. The foundations of the Educational System Act provides for preconditions for non-segregated inclusion of all children in the education system and their continuous education. An individualized approach has been established, and when necessary, individual education plans for students in need of additional education support are drafted by teaching staff of the respective institution in collaboration with parents. Members of national minorities may conduct educational work in Serbian language, their native language, or bilingually. In the Republic of Serbia, affirmative action of enrolling Roma children to secondary schools and universities is being undertaken, with scholarships and loans being awarded to pupils and students. The Constitution determines the right of scientific and artistic creation. In the Republic of Serbia, there is no difference in the protection of cultural properties relating to their origin. Acts governing the area covering activities conducted by institutes for the protection of monuments, museums, archives, and libraries, as well as standards of the profession of protection of cultural heritage, stipulate that all cultural properties must be treated and protected equally, no matter the time of creation and cultural provenance. Mr. Chairman, in conclusion, I'd like to stress that the Republic of Serbia, aware of the existing challenges, remains consistent in its efforts to meet international obligations and standards, especially in the sphere of promotion of economic, social, and cultural rights, which also entails active cooperation with international bodies dealing with these issues. We also see today's dialogue with the committee as part of this process. I am confident that we shall consider all matters which are of particular interest to the committee. For us, the dialogue will serve as a useful experience in our efforts to continue in improving and strengthening the system of human rights protection in the Republic of Serbia. Thank you, Mr. Chairman.
Thank you, distinguished and for your very interesting and very helpful introduction. I would like now to ask the committee's rapporteur on the Republic of Serbia, Mr. Walid Sadi.
Thank you, Mr. Chairperson. I likewise extend a very cordial welcome to the delegation of Serbia, and I look forward to a useful dialogue. I note from the statement of the leader of the delegation that since the first report, Serbia has adopted several legislations and strategies to give further effect to human rights in the country. And I think during this dialogue this morning and afternoon, with the cooperation of the delegation, we will have a sense of to what extent these legislative and strategic measures adopted have been translated and have taken effect on the ground. I think that's the whole idea of the exchange of information. Let me go back. Let me say at the outset that I note with satisfaction and appreciation the report of Serbia, which contained considerable amount of information, and I thank you and appreciate the contents of the report. I likewise must say that I read your answers to our list of issues again with a great sense of satisfaction, although some of the answers were incomplete, perhaps due to the pressure of time. Sometimes, countries work under strain under pressure of time, and hopefully during the dialogue today, we can complete the answers on an oral basis. What I admire most about your replies, Madam Leader of the delegation, is frankly the candor by what I would say calling a spade, to borrow an American expression, in the sense that you admitted where you have gone wrong, alongside where you took the right path. And I will try to identify these positive and candid answers, and perhaps also identify perhaps with the continued shortcomings. I therefore, like the chairperson has mentioned, my task now is to make rather general, brief comments and observations on the first cluster of issues. My colleague Renato Roberto on my left, my learned colleague and friend as well, has accepted to take on cluster 2. This will give you some element of relaxation from my voice and my line of questioning, and so I'm grateful to my colleague for doing so. Now, regarding the usual and primary concern of this committee, which is, of course, as you can understand, is the status of the covenant. While noting that the covenant forms an integral part of the legal system of Serbia and is, in theory, directly applicable, I'm afraid to say there is hardly any case law on its application. Maybe there is, maybe there isn't, but as far as I could tell, there is nothing that you have provided us with to show that in reality the covenant is applicable and has a justiciable status in the country. You have also mentioned the protector of citizens who deals with several economic, social, and cultural rights. But there's no way of knowing whether these rights are ones and the same as the ones stipulated in the covenant. You see, there's a rather tradition or custom by many state parties to say that we have laws on economic, social, and cultural rights, and we protect them and promote them. But what we would like to know for sure, whether your conception of economic and social rights correspond with the principles of the covenant, and maybe through this morning and afternoon dialogue you can tell us for sure what is the status of these economic and social cultural rights in your country. You have also made reference to the protector of citizens, or the commissioner, and the Commissioner for the Protection of Equality, but we do not know till now whether these human rights institutions meet the Paris principles. As you know, it has become a rather tradition, not by our committee, but I think by all treaty bodies, to press on this point about the Paris principles, because it's the only sure way to know whether the human rights institutions are effective and have the wide jurisdiction required of them to promote and protect human rights. And while I am at this juncture, I note from your title that you are the Director of the Office for Human Rights and Minority Rights of the Republic of Serbia. Does this suggest that minority rights are acute in your country? Because, you know, by saying human rights and minority rights, in other words, you highlight minority rights. There's nothing wrong with it, but it does suggest, to me at least, that minority rights have acquired special attention from you, which also implies that minority rights pose a problem, or let's say a challenge, to your area of activities. I stand to be, of course, corrected on this point. With regard to discrimination, which, as I said, is so central and basic to our dialogue with you, I noted that you have the law on the prohibition of discrimination earmarked to protect, according to your words, 9 vulnerable groups. First of all, I don't know who are these vulnerable groups. And we don't know for sure whether the basis of discrimination that are prohibited meet the requirements of the basis of Article 2 of the Covenant, which seems to be a much wider one than what you have. Perhaps this omission is not on purpose. Maybe the omission is not correct. My understanding of the omission is correct, but I hope that you will, in due course, correct me on that one as well. We would like to know the results of the application of this law on the prohibition of discrimination by citing concrete examples where it succeeded in combating discrimination. In other words, it's so nice to hear that a country has laws against discrimination, but until we have concrete cases, how this law has been applied, with what results. I'm sure you have available to you some samples of the positive consequences of this very encouraging piece of legislation. The case law you referred to in paragraph 26 of your replies to our list of issues does not give a detailed account of how the 30 cases mentioned there were all dealt with. There's a reference to 30 cases on discrimination, but I'm at a loss to know what happened and how they were handled, with what results. Maybe through this morning, through you, Madam Leader of the delegation, you can tell us some more on this. Where I admire your report, and I must register this because this is one of the many key elements of your report, where you admitted that the strategy for the improvement of the status of Roma has effectively failed. You said so. Paragraph 28 of your, on the answer list of issues, replies to our list of issues. This is great, and I wish other countries would do likewise, to admit, and to, I don't want to say confess, to admit where the strategies they have failed. I think this will make our dialogue that much more constructive. Where you also may, if I'm not a professor, but if in this position, where I would give you high marks as well, is on the effects of privatization in Serbia on the enjoyment of economic, social, and cultural results. You were quite candid, and I admire you for that. You said that the results of the study you have conducted on the effects of privatization confirmed that privatization did not produce expected results. In other words, for all intents and purposes, it has failed. I admire you for this candor, and I wish other countries would do likewise. In actual terms, privatization you reported to us led to a slow economic growth, high unemployment, and low investment, and high investment for non-productive companies, among other things. In other words, you concluded that privatization had negative consequences on the implementation of economic, social, and cultural rights. I wish you would send your study to the IMF and to the World Bank, because they keep pushing countries in that direction. But your studies, your experiences would help out in understanding better the impact of this kind of macroeconomic policies. In another vein, you admitted in your list of your answers that hate crime is still rampant in the country, and that the incidence of ethnic intolerances are still widespread. Well, I must give you credit for admitting that the problem with hate crime still continues, but I'm just wondering what really, not legislative measures or strategic matters or strategies, what in fact can be done to deal with this hate crime, and how to deal with incidents of ethnic tolerance, because you see, they could be the foundation for the realization of economic, social, and cultural rights in a country where there's considerable degree of hate crime and where there's considerable amount of ethnic intolerance. These would erode the foundations for economic development. On the Roma, which is not unique to your country, you have something that few other countries have done, and I must give you credit for that again. In paragraph 54 of your answers, you tell us that subsidies are being offered to employers who employ up to 20 persons of Roma. This is great. In fact, every country that has a Roma problem or challenge, I'm going to refer your example to them, whether they can emulate your example. Maybe this is the way to deal with the Roma problems, by subsidies to companies. But since this is a beautiful way of dealing with it, are you in a position to give us examples where and how these subsidies were indeed offered to companies that employ 20 persons of Roma? With regard to refugees, asylum seekers, and internally displaced people, you also, again, admit that you still lag behind, not because on purpose you lag behind, it's because the challenges are so formidable and the magnitude of the problem and the challenge are so big. On one hand, for example, you say that you have this cooperation with BIH, Croatia, and Montenegro to end the 1991 displacement crisis and have created a national coordination mechanism to resolve the problems of Roma persons of undetermined nationality and establish a procedure for registering the birth of children whose parents cannot fulfill the residency requirement. The 2008 law on asylum, you also tell us, has not functioned well, or at least we conclude has not functioned well, by virtue of the fact that very few people have profited from it. I think only 3 or 4 people were processed under the law of asylum. There must be some reasons why this law on asylum, which is very encouraging on paper, why it has not functioned well in reality. The year 1992 law on refugees, again, is very good law, and I think it's very commendable effort on your part. But it seems to me that had failed to integrate refugees and displaced people till now. The refugees in your country, I know you have made considerable efforts to integrate them. Maybe because the problem is so wide and big, you have not been able to integrate a sufficient number of them. Discrimination against, this is where I'm going to conclude, Mr. Chairperson, I'm about the end. Discrimination against minority religious communities continues despite your reported efforts to combat them. I know you are making an effort, but the problem continues. On gender equality, Serbia seems to be doing the right thing again by evidence of the policy and practice of requiring employers who employ more than 50 persons to adopt a plan to combat unequal gender employment opportunities. Again, this is where other countries can learn a lot from you, because perhaps this is the best way to promote gender equality, is by requiring companies to have such a plan. And I think countries can learn from you on this in this context. You have a Council for Gender Equality to examine and recommend measures for developing policies aiming at achieving gender equality. Yet, this promising council has held only 3 meetings since 2004. Why? With this comment, Mr. Chairperson, I conclude and I leave, like I said, the cluster 2 to my learned colleague on my left. Thank you, sir.
Thank you very much for this statement. And now I would like to open the floor for the speakers who have already put their names on the list, and the first speaker will be Mr. Kardun, and the next one will be Madame Brash Gomez. Mr. Kardun, the floor is yours.
Merci beaucoup, Monsieur le Président.
Thank you, Mr. Thank you, Mr. Chairman. First of all, I'd like to welcome the Serbian delegation here today to discuss the second periodic report of the State Party. Of course, I will have some questions to ask. My first questions I will ask in the first group, and then later on in the third cluster I will have some questions on another article. For the first group, the first cluster, Article 2, Paragraph 1 concerning corruption. A question was asked to you by our committee, which of course asked you to provide information on measures which the State Party should take precisely to fight corruption, with a view to maximizing resources for the enjoyment of economic, social, and cultural rights by the population, taking into account the general observation number 3 of our committee. Of course, I have read the reply which you gave us to that question, but I must say that the phenomenon of corruption is not specific to Serbia. It affects many countries. Many countries, and not the smallest ones either. And when there is corruption, the entire country suffers. It doesn't succeed in emerging of getting rid of this phenomenon. But what I have seen from your replies is that your country seems to be aware of this phenomenon of corruption, for the simple reason because you have decided on a national strategy against corruption for the period 2013 to 2018. In other words, you have already begun the first year, 2013, to combat corruption. And that strategy is also backed by a plan of action which provides for specific steps to combat corruption. And you have also created an agency, an anti-corruption agency, which is independent. These elements show that you are tackling this question of corruption seriously, and I commend you for that. The questions that I would like to ask concerning corruption in your country. Question number 1. What is the extent of the phenomenon of corruption in Serbia? How widespread is it? In other words, does it hinder the enjoyment of economic, social, and cultural rights for the population? My second question on corruption is that the committee would like to know what are the various areas of activity and agencies where corruption is particularly common. For example, perhaps in the public administration. Is this phenomenon known in the public administration, in state services, in public enterprises, in private enterprises? This is an important question to get an idea of the extent of this phenomenon, whether it is spread to the entire society or all state services, or whether it's fairly restricted and can be limited to a certain number of sectors. In other words, what I'd like to know is what sectors of activity economic and financial areas of activity which are affected by this phenomenon of corruption. And knowing which areas this is the case for, would give us an idea of what efforts might be made for a given sector or administration to combat this phenomenon of corruption. For example, in some countries, yes, Mr. Chairman, I will try to speed up. In some countries, corruption in the civil service is such that it's impossible to get a birth certificate without giving something to the official in charge of that. That is a very serious situation. The third question is that we would like to know when an instance of corruption is identified, what sanctions are imposed against the official according to legislation. And if these sanctions are imposed, I'd like to know whether these sanctions are financial or judicial. And does your criminal code provide for serious penalties against corruption? And finally, my last question, because I have to go faster to allow my other colleagues to speak, could you give us some cases of corruption in your country which have attracted attention in the media in Serbia and which pose a major problem in the such a problem that the media have addressed them? Thank you.
Thank you very much. I'm sorry that I am trying to draw the attention of my distinguished colleagues in the committee to the actual time of our debate, and I really need to say that with this speed we will not be able to stick to the scenario we have adopted for our meeting today. Therefore, I would like to appeal for limiting the interventions to the necessary points and in a very succinct way. Sorry for this request, but this is just in view of is made just in view of the time which is really running out. Next speaker is Madame Brash Gomez, and she will be followed by Mr. Scriver.
Thank you, Chair, and a very good morning to the delegation. I would like to follow up on some of the issues my colleague, Mr. Sadi, just raised. Like him, I would also like to thank you for the critical assessment of what has gone right and what has gone wrong, and that is what this dialogue is all about. In relation to the issue of privatization, Mr. Sadi has already raised the issue. I would like to follow it up with some information you've provided in the paragraph after paragraph 34 on the effects of intensive industrialization and urbanization. And you tell us that this intensive industrialization and urbanization has in part been responsible for lagging behind in socio-economic and cultural development. And we all know that without sound economic, social, and cultural development, there can be no real implementation of economic, social, cultural rights. You talk to us about a sustainable development strategy, and you enumerate the strategic objectives. I would just like to ask you for further information, some examples on how you plan to combat the negative effects of this industrialization in this sustainable development strategy. There's no information on the strategy, and I'd like to ask you, particularly in relation to one objective, and that is the use of natural resources. That is one area where in the committee we have seen that privatization has had industrialization, privatization, development without the necessary safeguards has had a very negative effect. And so I would like to ask you for some examples in this strategy that deal with the issues of privatization and urbanization in relation to natural resources, to see how you're planning to combat what you already know has not worked well. In relation to discrimination, Madam Head, am I speaking too fast? Is that your... All right, I'll try and speak slowly. In relation to discrimination, Thank you very much for the information and for what you've provided in your opening statement. You have given us the list of grounds for discrimination. In your new law, it is an extensive list. But you also tell us that the discrimination, that the Act prescribes two methods of achieving protection of citizens if there has been a violation of protected rights. You will agree with me that in order to be violations, people have to know that they have those rights. They have to know what the legal framework is, how they can use it. And I ask you that because from some information we have provided by the United Nations in Serbia, we have some information that there was this study undertaken by the Commissioner for Protection of Equality in 2012, and this study came to two findings: that there is a large number of people who do not know that discrimination is prohibited by the law, and that 55% of those who are aware of the legal regulations doubt its adequate implementation. So my question to you is, what can you do to further develop information, knowledge, awareness raising, so that people know what is the legal framework in place? Thank you, Chair.
Thank you very much, Madam Gomez. Mr. Shriver, the floor is yours. You will be followed by Mr. Tangana.
Thank you very much, Mr. Chair, and welcome also from my side to the delegation. Obviously, a lot of activity took place in your country during the period under review. I'm particularly impressed by your legislative reform agenda in recent years. My colleague Kerdoen raised already very good questions as regards corruption, so I skip that point because he posed them in a much better way than I had prepared, and I look forward to see your answers to it. Secondly, I would like to briefly raise the sensitive issue of the status of Kosovo. If there is any country in Europe faced with territorial disintegration, I believe it is yours in recent decades. And I wonder whether you could inform us how you view the current situation. Is it a kind of status quo of conflict freezing, or are you still hopeful that solutions may be found? I also ask so because only 1 week ago we had the Ukraine in your seat here, and that also raises once again discussions on your particular experience. So it's just for our information, what is your current conception of the status of Kosovo? The next and last issue relates to the issue of refugees. Madam Head of the Delegation, in your opening statement you reported that your country has a very high number of refugees, more than 57,000. So my question is, what are their countries' regions of origin? And is Serbia mainly a country of transit for refugees, or do many refugees would like to stay, to reside within your country? It has come to our notice that only a few persons received refugee status in Serbia, despite the fact that you adopted in 2008 a new interesting law on asylum. We are also a bit concerned about the fate of the children of refugees. Do they really fully enjoy their right to education, at least at the elementary and secondary level? The children of asylum seekers, and if they stay longer, can they really integrate into the ordinary schools, or is that arranged in a separate way? These are my questions, Mr. Chair.
Thank you very much. And now Mr. Atangana will take the floor, and the next speaker will be Madam Heisu Shin. Mr. Atangana.
Merci, Monsieur.
Thank you, Mr. Chairperson. I would also like to welcome the delegation of the State Party. Several points that I wanted to raise have already been mentioned. In particular, the role of the covenant and its status in domestic legislation and the enforceability of provisions of the covenant. The rapporteur has already addressed this point, so I will not revisit it. There's also the question of corruption. That's already been mentioned. Now, concerning the presentation of the report, the rapporteur has already told you that we value the frankness and the clarity of the information provided. I've also appreciated your approach, that is, of presenting replies to our earlier concluding observations in your report. But there is one aspect here. In paragraph 1, you started by responding to paragraph 39. What about the earlier paragraphs of the concluding observations? You left those out, from what I can understand. Anyway, we started from 39. I would welcome clarifications on that. Now, concerning the judicial system, you have mentioned that in order to ensure the independence of the judiciary, there is a body in your country which is responsible for ensuring this, an independent body, the High Judicial Council, I think it's called. Now, the President of the Supreme Court, the Minister of Justice, and the President of the Permanent Commission are fully fledged members. I would like to know who chairs this council. Who is the president of the council? Thank you.
Thank you very much, Mr. Tangana. Madam Shin, I would like to ask you to take the floor, and the next speaker will be Mr. Bashidze.
Thank you, Mr. Chair. And my congratulations to the delegation from Serbia for all the improvements that you have made in implementing the concluding observations as well as the covenant that we are discussing. I have three concerns that I would like to raise. The first is regarding the civil society. I don't get a picture how vivid and live your civil society is. In our previous concluding observations, we asked that you disseminate widely our concluding observations, and you answered that the associations are actively included in preparation, and I hope that they were meaning NGOs, but I don't have the picture of how many human rights NGOs working in the area of economic, social, and cultural rights there are. So I would appreciate your explanation, and how were they involved in the preparation of the report? In what way? And are they the partners of the government policy formulation or legal reform, not only in the process of implementation, but also in evaluation of the policies? My second question is regarding your National Human Rights Institution, the protector of citizens. And I'm happy to hear that you have now law covering possibly all grounds of discrimination, which is commendable. This protector of citizens are getting a lot of complaints. And my question is, have you classified these complaints according to the ground of discrimination? Because that would give you in what area you need to work further not only in the area of employment or housing, etc., but also according to the racial discrimination, gender discrimination, or disability, etc. So I would like to know what are the grounds of discrimination that the complaints are mostly filed. And one additional point regarding this National Human Rights Institution, I have the information that there is no possibility that this institution can interact with the international human rights system, nor with the civil society. So is it because of the limitation in the law itself about it? Why this institution, which has A status, by the way, cannot interact with international human rights system or civil society? I cannot understand. So maybe you can explain. My third and final concern is regarding gender equality. You have all the necessary frame. You have the law newly adopted. You have the quota system that seems to be working. And you are also trying to bring equality in the area of employment. But it seems like the Directorate for Gender Equality, as you explained in your replies, is equipped with only 5 persons, including the executive. So how can 5-person agency do any real meaningful work, for the issue of gender equality? And also this issue of Council for Gender Equality, which met only 3 times during 10 years. Is it just symbolic, or can it really work and function to bring any real result in that sense? So what are the difficulties? Is it again the difficulty of budget allocation, and how can you make sure that this directorate as well as council can perform its function and can bring gender equality in the real sense? So where are the difficulties lie? Thank you very much.
Thank you very much, Madam Shin. I would like to call on Mr. Abashidze, and the next speaker will be Mr. Abdelmoney.
Thank you. First of all, I would like to welcome the delegation, the high-level delegation, and I would like to also say that I have carefully read through all the information, and I have been struck by the following. That is something already remarked by our rapporteur. That is the way in which you have dealt with minorities. I would like to point out that Yugoslavia, historically speaking, played a big role in developing Article 27 of the Covenant on Civil and Political Rights, where reference is made to refugees. I just wanted to remind colleagues of this fact. And it is heartening to see that there is highly developed legislation on minorities, inasmuch as the state not only has a ministry on human rights and national minorities, but it also has a law on protecting the rights and freedoms of minorities. And what is most important and what distinguishes this law is that it has a definition of minorities. And this is particularly striking because when we deal with other states, there are some states that totally deny the existence of minorities, and there are others that include these issues under the work of a different ministry without any reference to minorities at all. So Serbia, I think, in its approach, in terms of legislation and in the way it is set up, is doing a good job, because there's also the Council on the Affairs of Ethnic Minorities in Serbia, and headed up by the Vice Prime Minister, which is also very significant. So in this connection, I would like to point out in particular that also that among the minorities, I found minorities such as Rusin. They have the status of being minorities, and yet most of these people in Serbia don't seem to want that status. They have rejected that status. So according to existing criteria, everyone who meets the requirements of the definition of the law, have they received the status of minorities, or have there been any problems in this connection with getting the status of minorities? If so, could you please describe what happened? Were there obstacles of a conceptual nature or technical nature or some other kind? Or what sort of barriers existed preventing these people from getting the status of minorities? That's my first question. The second one, I would also like to go on to say that I have been very impressed by the names of the other ministries. There's the Ministry on Labor, Employment, Veterans, and Social Affairs. I am very impressed when in ministries' names we see a specific reference to veterans, because we have a general problem of the aging of the population throughout the world, and this includes Serbia. It is a very important issue. So what happens is that on the one hand we are raising the pension age, and yet at the same time we're talking about gender equality. And I'll give you an example of what I mean. This is my question. For men, the pension age is 65. For women, it's 60. Now, the life expectancy for men is 69.5. For women, 75. So what happens with that is that the men are in the minority, if you like. They're dying out. So perhaps we should lower the pension age to 60 for men as well. Why should we see gender equality only in one direction? Of course, I have all respect for women, but I think we have to have the same sort of respect for men. And the statistics are that in 2008 the population was 7,350,000, and older people over 61,650,000. So every 1 in 5 people, according to 2008, we'd have to look at the 2012 figures, but this is a large number of people we're talking about. Another issue, you have the principle of solidarity, and that's a basic one, but there's this aging I've already mentioned, and do you take into account equality here? What happens is that we are resolving economic issues, taking into account the state's priorities, but we sometimes violate gender equality and actually engage in discrimination. Thank you very much. These are my questions.
Thank you very much, Mr. Abdelmonem. The next speaker, but already under Cluster 2, will be Mr. Ribeiro Leao. Mr. Abdelmonem, and I would like to really request my colleagues to finish the interventions as, let's say, succinctly as possible. Thank you.
Thank you, Chair. I want to extend a warm welcome to the esteemed delegation of Serbia. I do highly appreciate the statement by the Madam Head of Delegation, very comprehensive. I also appreciate the reports. You already know that the job of the committee is to estimate to what extent the country had fulfilled its obligations under the covenant. That is the progressive fulfillment of these obligations to the maximum available of its resources. In this context, I want to refer to page 79, tables of your page 79 of the core document of Serbia. That's exactly tables 10 and 11. The consolidated public expenditures of state sector structure by functional classification in the period 2005-2008. understand that Table 10 is based on GDP percentage, whereas it seems to me, to my understanding, that Table 11 takes public expenditures as the point of departure for estimating other expenditures. I'm gratified to note in this respect that the expenditure, take first, for example, the first table, percentage of GDP, expenditure on housing and community, healthcare, recreation, sports, culture, and religion, education, social welfare, all these belong to the rights in the covenant, amounts to about 1/3 of the consolidated public expenditure 2005-2008. However, I'm a little bit worried that housing and community is only 1.5. That's much less than defense. Culture, among recreation, sports, religious activities, is 0.9. That's much less than defense. Of course, I must say that if I compare social welfare to defense, that's a very gratifying result. It's a very good indicator. I hope others will follow that. However, a couple of questions just to understand better the tables. The words public expenditures, do you mean here in terms of public finance terminology, do you mean government expenditures or general public expenditures? Why? Because if it is general public expenditures, then it could even pertain to social, economic, and cultural rights. So there must be an additional percentage. The same applies to economic activities. Which kind of economic activities? Stabilization of employment, for example, subsidies for unemployment. That's also need to be clarified, because if this is the case, then the percentage should be more than what I calculated here, about 1/3. Speaking about statistics, I must recall I come from a country, Egypt, where our Central Statistical Bureau was established with the help of experts from Belgrade at the time, and also our Central Economic Planning Institution was supported at the time by your country and even modeled to what you had. Thank you very much.
Thank you very much. Now, these were questions under Cluster 1. We are starting with Cluster 2, and here Mr. Ribeiro Leao is a member of a team which was under leadership of Mr. Sadi, was preparing this guidance for our dialogue today. Therefore, Mr. Ribeiro Leao will speak as the first and will make a sort of introduction to this cluster. He will be followed by Madame Bras Gomez.
Gracias, señor presidente.
Thank you, Mr. Chairperson. First of all, I would like to extend a warm welcome to the delegation of the State Party. I look forward to a frank and constructive dialogue. Both the contents of the second periodic report and the answers to the questions and the list of issues and the introductory statement by the head of delegation have given us a whole range of information that helps us to embark on an interesting dialogue on Articles 6 to 9 of the Covenant. As a result, relating to Article 6, the right to work, it is important to describe measures taken to ensure opportunities for jobs in public and private sectors in such a way as to meet with or to deal with the problem of 25% unemployment. In addition, what are the measures taken to combat informal employment? Also, in the light of the national strategy on equality, I would like to know how Serbia is dealing with discriminatory attitudes and practices concerning access to the workforce for Romas in the public and private sectors. We would also like to know what measures have been taken to promote employment for persons with disabilities. Turning to Article 7, the right to equal working conditions. We would like the State Party to clarify the way in which you calculate the minimum wage and the way it is periodically revised. In other words, what basis do you use for this purpose? Now, concerning health, security, and work hygiene, how do you collect data on these issues, and what are the strategies applied to cope with the problems that are detected as a result of that monitoring? Concerning Article 8, the right to form trade unions, in the light also of paragraph 145 of the report and the introductory statement by the distinguished head of delegation, please describe the strategies used to promote the right to establish trade unions in the private sector. With respect to the right to strike, in the light of paragraph 153 of the State Party report, second periodic report, please clarify if among civil servants or employees in the public sector there are any restrictions on the right to strike, say in the sectors that are considered essential. And also, please describe which services or sectors are deemed to be essential in the public sector. Lastly, concerning Article 9, the right to social security, we would ask you please to elaborate on the efforts made to guarantee the right to social security for boys and girls without families, and also to relatives of families in crisis. That's all I have to say for now. Thank you very much.
Thank you very much, Mr. Ribeiro Leao. And after Madame Brash-Gomez, Mr. Scriver will take the floor. Madame Brash-Gomez, the floor is yours.
Thank you, Chair. Following up on what my colleague, Mr. Leao, has said, I would also like to ask, you have information in your report and in your replies to the list of issues that illustrate that there's still a disparity, a considerable disparity in employment rates and activity rates of women and men. There's a disparity of 16.5% in the activity rate and of 14.1% in the employment rate. I know you have taken a number of measures. Not all of them have seemed to have had impact. What can you take by way of corrective measures? What are you planning for the future? Learning from the experience, what are you planning for the future? In relation to the issue my colleague raised on the employment of Roma, we have some information here from European Roma Rights Center and the collective of Romani grassroots organizations, and I'm sure you're familiar with their work, that specifies a few reasons why the exercise of the right to work for Roma is curtailed. And among these reasons are complicated procedures, conditions for obtaining documents required for employment. And this affects not only Roma, but also IDPs. And in the case of the IDPs, one particular issue seems to be the obtaining of a work booklet, which is not easy. And that makes it very difficult for them to find work. The same seems to apply to access to the right to Social Security. It's the lack of these personal documents that also makes it very difficult to enjoy the right to Social Security for Roma and IDPs. And there's an additional problem is that the social welfare centers, which are frontline services for everyone, it would appear, they're not very friendly towards undereducated clients. So They do not really provide information. You know, they just tell them what lists are, what documents are necessary, and that's it. And for people who are in vulnerable situations, that is hardly the way to get them to collaborate and to feel respected in the enjoyment of their rights. In relation to Article 7, we have some information here on labor law cases against Serbia in front of the European Court of Human Rights. And they basically have to do with the liability of the state for the debt of state-controlled companies that have been in the ownership of the state, then were privatized and came back to the state for various reasons for which we do not have the time now to go into. But the bottom line is that there are salary arrears and social security contributions arrears in the case of these companies. They are no longer present as they were before. They are now privatized. Some of them are probably closed. For whatever reason, someone has to take responsibility, and it would seem that the state has refused to do so. And there's even been a constitutional appeal implemented. I just wanted to know the state of the art. What do you think now? Is there any possibility that you may have moved forward in your thinking in relation to these workers' rights, which if the state companies do not respect them, the state has a responsibility towards those workers? Finally, in relation to social security, I wanted to ask you, there seems to be this break of 3 months after 9 months enjoyment of the right in relation to the unemployment benefit, and it would seem that the same applies to people who are not eligible for old age or disability pension. So they get it for 9 months, and then if the need is still there, they will get it for 3 months. They will not get it for 3 months, and then they will get it again. If that is right, in my understanding, what happens to these people during those 3 months? What is the kind of social security protection they would be entitled to? Because basically they're the ones, that is the time when they most need it, because you don't know if they still need it after 3 months. But what happens to them during those 3 months? Thank you very much.
Thank you very much, Madam Bras-Gomez. After Mrs. Schreiber, Madam Kong will take the floor. Mrs. Schreiber, the floor is yours.
Thank you. My first question relates to the right to work. We noted already that the level of unemployment is alarming. It's very high. You have provided us with a lot of statistics and information on your strategies to combat unemployment. However, I found very little information about the unemployment among young people. Could you provide us some information on that, and could you also provide the information on the measures you are taking to increase the access of young people to the labor market and to provide them also with sustainable development, sustainable employment opportunities? My second question relates to Article 8. I'm really impressed by the number of trade unions within your country. You, Madam Head of the Delegation, also mentioned in your opening statement that you have as many as 20,000 trade unions. What is the background of this diversity of trade unions? Sometimes it is an employer's dream to have so many trade unions that they can't make one fist. Is that behind it? Is that indeed also the dream of your government, now that we read that the trade unions are especially in the public sector, and that in fact there is still a very low number of enrollment of workers in the private sector? So my last question here is, how do you explain that to join a trade union in the private sector is still not popular? Has that to do with the unemployment, for example? Thank you.
Thank you very much, Mrs. Schreiber. Madam Kong, the floor is yours. The next speaker will be Mr. Martynov.
Thank you, sir. I'm very pleased today to see the presence of the delegation of Serbia in our committee. I thank the head of delegation for her opening statement. My questions relate to Article 6. My colleagues have answered many questions. I will ask 3 questions. Question 1. The paragraph 144 in the replies mentions that the low share of private sector employment exists and the subsidies provided to employers have not produced remarkable results. So what more effective measures does the government plan to take to encourage and standardize the increase of employment opportunities in the private sector? Question 2. Replies in para 140 refers to poor labor force mobility, especially that which affects the women. Departments concerned in the government or academic agencies, have they had done any more deeper and comprehensive analysis of this issue? There are 42.1% of women in employment. So employment for women is a good thing because it adds to the income of the family. What more nuanced measures does the government plan to take to effectively reduce the low employment rate of women? Last question related to the issue number 9 in the replies. Page 11 provides the data according to which the total population of Roma was 147,604 according to the 2011 census. Para 48 mentioned that in June 2009, National Employment Service set up records for Roma for the first time. And in that year, there were 13,416 Roma registered. And the same figure for 2013 was 22,102. Why there were so few Roma registered in the NES. In addition, para 49 provides a table which shows the number of Roma included in active employment policy measures. Some measures only included 1, 3, 4, or 5 persons. The number is very low. My question is there any discrimination against Roma in employment registration and training, or the information provided to Roma has not been sufficient? As a result, they do not know what to do in employment and what rights they have. Have you conducted any more effective education or incentive policy measures with regard vis-à-vis the employers? Thank you, sir.
Mr. Martynov, the floor is yours.
Thank you, Mr. Chairman. Mr. Chairman, starting with the right to work, I would like to make something like a comment on this issue rather than a question. The head of the delegation indicated to us that the most recent figure for unemployment rate for 2014, that is about 21%. And 5 years ago, in 2009, it was 17%. So, in my view, that indicates that the measures which have been taken by the government in the recent years did not yield the necessary result, since the unemployment rate is actually growing and growing fairly substantially. Now you have, since 2011, a new potentially powerful instrument, which is the new national employment strategy for the period of 2011-2020. So my hope and request, in fact, to the delegation is to see that this new strategy is built not on the previous recipes which proved to be ineffective, ineffective, but rather on new approaches. And we, of course, would be very happy to see at the time of the next periodic report detailed information from the state party about the impact of this new strategy on the situation in employment. Now, the next issue. You indicated in your replies to our list of issues that in Serbia there are, and I'm quoting your replies, intense territorial disparities in development. Now that, in my view, of course, means that there are also intense territorial disparities in employment. The question is whether this new strategy for 10 years in employment, does it have a specific emphasis on trying to address the issue of territorial disparities in employment and development? The next questions relate to persons with disabilities. You have adopted fairly recently a law on professional rehabilitation and employment of persons with disabilities, and it seems that it is working. At least it provides tangible results in terms of the number of employment opportunities which have been created and the number of persons with disabilities who are employed. And this is quite commendable. On the other hand, as you indicated to us in your report in paragraph 27, and I quote, "There are no records of the number of disabled persons." This is a kind of a puzzling admittance on the part of a state party which is a party for already 5 years to the International Convention on the Rights of Persons with Disabilities. And in the absence of records of the number of disabled persons in your country, how can you evolve a strategy, a meaningful strategy to address this painful issue? The question and the request is to whether the government intends to proceed as promptly as possible to creating a database for which would contain the records of persons with disabilities. Now, you indicate in your report that the rate of unemployment for persons with disabilities is less than 14%. Which is a strikingly low indicator. It could have been great, yeah, if it was real. But you understand, as I see from your own report, that this is a bit unnatural, and you explain this very low rate of unemployment among persons with disabilities by the high rate of inactivity of this category of persons. Now, that may well be the truth, the inactivity in on the job market. But in my view, that means only that there is not enough effort by the state party and not enough opportunities for this group of vulnerable people to be socially included. Not enough vocational training, not enough openings, etc., etc. So, hopefully the new strategy on employment will also address the issue of social inclusion and provision of jobs for persons with disabilities also as a specific target and part of this program. So this is both a question and a request. The next issues relate to Article 9. And the first question again relates here to persons with disabilities. How the state party ensures social protection of persons with disabilities under the conditions that it doesn't have the records of such persons, the list of such persons. So I would be interested to know what is the extent of the social protection of persons with disabilities and how it works in the state party. In our last concluding observations, this committee was very much concerned with the very low unemployment benefit coverage in the state party. You have a special comment to that particular concern and recommendation of our committee, but unfortunately in this comment you did not inform the committee whether the unemployment benefit was raised in the recent years, what is the current level of unemployment benefit, and how does it compare to minimum subsistence level. I would be very much interested to learn that from the delegation. You also did not indicate the extent of unemployment benefit coverage, which this committee was asking about. So the next question is, what percentage of the unemployed actually receive financial unemployment benefit? Now, again, in 2005, at the time of the previous consideration of your report, our committee was concerned at possible consequences at that time of stricter eligibility criteria for the which were contained in the then new law on pensions and disability insurance. And we asked you a direct question of how many people will lose, so to say, the eligibility rights under the new, more strict law. Now the head of delegation has informed us that in 2010 there were new amendments to the same law which made retirement requirements even stricter than in 2005. So the question is, what is the impact of the new stricter eligibility criteria for retirement for old age persons in the state party? How many people lost their right to pension, or what are other ways in which this category of people were affected by that? And then finally, last question. The head of delegation mentioned that, and I'm quoting, mandatory insurance covers all employees, persons independently performing activities as well as farmers, which is a very commendable step by the state party because it addresses the issue of informal sector and provision of social protection to persons who are engaged in informal sector. So the questions are the following. What is the enforcement mechanism for this mandatory insurance in the informal sector? Is it a labor inspection? Then how many inspections does it do to make sure that this is implemented? And what is the enforcement procedure, so to say, in this case? And then the head of state mentioned that there is an option of voluntary insurance for persons who are not mandatory insured. But this seems a bit strange because the definition of those who are mandatory insured seems pretty comprehensive, all-encompassing. So what categories of persons are not mandatory insured in this case? Thank you.
Thank you very much, Mr. Martynov. We have, in this way, we have come to the end of the list of speakers under cluster 1 and 2, and in accordance with what we already agreed upon, I will adjourn the meeting for 15 minutes. This means that we will reconvene the meeting 12:10. Thank you very much. The meeting is adjourned.